All right, good afternoon. This is the matter of Dakota Mortensen and Taylor Paul. Case number is 25490-3375. Council appearances, please.
Chad Shattuck for Dakota Mortensen, who's also here in my office with me.
Okay.
Good afternoon, Your Honor. Eric Swinyard for Taylor Paul. She's here with us. Also have co-counsel Ryan Ficklin here in our conference room.
All right, very good. So we're here. Oh, I'm sorry, Ms. Satterley. Welcome.
Thank you, Your Honor. Thank you. Allison Satterley, private guardian ad litem.
All right, so this was scheduled as a parent time review hearing. I want to make sure that everybody was on the same page about that because I received a very disconcerting, voluminous document dump yesterday. A lot of it seems to be relative to the motion to set aside the stipulation. Mr. Shattuck, why don't I start with you?
Okay. Well, we certainly agree that the purpose of today is to review parent time, and provided the court a summary that we thought would be helpful. Doesn't address a bulk of the motion to set aside. That's something to be heard by the judge, and we'll get a hearing set on that once it's fully briefed. In looking at the custody and parent time.
Hold on, I'm not asking you to go into on the merits yet. We're not there yet. There's also another motion too. It looks like a stipulated motion with respect to consolidate some sort of, well, you characterize it as a Rule 100 motion. It looks like you wanted, everybody wanted to, A, that the case be classified as private, and B, that all the hearing and all of the, well, really there was two remaining matters, which are the domestic matters, that they both be heard before Judge Mao and me. There's some issues with that, but I also think that should go to Judge Mao. And the issues, one, are that there was already a stipulated motion to seal the file, and then also there was another motion to keep the media coverage from the file, from the hearings. He had made a ruling on those in one of the protective order cases, and he said no, the parties had not met their overcome the presumption of the open courts provision that we have. So just letting you know that. And then I think there's another issue with the in terms of the Rule 100 aspect, is that it's not the same parties in the rule talks about it when it's the same parties. I think the motion sort of characterized it as close enough, but the case that Commissioner Loon has one of the parties is different than the case that I have before me. I'm just bringing that up, but I think that motion also needs to go to Judge Mao for resolution, because that was brought in this case.
Your Honor, can I speak to the previous motion to seal?
Oh, I'm going to ask that. I'm going to say this too. This is already classified as private. That at least we have open courts. Anyone can attend the hearings, and the pleadings are not available to the public. They're not downloadable, but the orders are public. That's the difference.
Your Honor, a couple comments.
Yes. Yeah.
A couple comments on the previous motion to seal. One, it was a different case. It was a protective order case.
It was
much narrower in scope. And I do have to point out that it actually was not a stipulated motion to seal. There was some confusion there because we had originally worked on it as a stipulated motion to seal, but then the stipulation fell apart. So my office filed that.
Well, my point was that he made a ruling about it.
Okay.
Right.
I don't have any concerns with the court's direction to have Judge Mao address it. But again, there are some very key differences with it. It's a different form of relief that's being sought. The one that was submitted earlier today is a genuine stipulated motion to seal. And it seemed to me from Judge Mao's comments back in April that part of his concerns stemmed from, well, is this kind of standard evidence and standard issues that are being brought forward, or are there more sensitive issues, more sensitive materials such as medical records, mental health records? And at that stage of the case, that hadn't played out. Those had not really come out and become a theme in the case, but now they are. And so now the case has gotten a lot more sensitive. When
we met before, when that motion was filed the first time in the protective order case, he indicated, and I think it was in his in a minute entry that he provided, that he would hear it because it could affect the entire case and not just the one hearing at issue at that time. All right. So I'm just certifying that to Judge Mao. And if you get a hearing date from him on the motion to set aside the stipulation, I think you could probably hear these at the same time when you get a hearing date. I know there's a request for a hearing that was put in by way of filing. I just suggest you pick up the phone and call his team and get some proposed dates to initiate that process. They'll email you back with proposed dates. All right.
We will follow up with his team, Your Honor.
All right. All right. So let's get into the parent time issues. I did see some affidavits, some updates for the court, and we have Allison Satterley now on the case. Previously, it had been Mike McDonald, who was from the Office of Guardian Ad Litem, who would be appointed in the protective order matters. Ms. Satterley, as you know, is a private guardian ad litem who's a practitioner and is her first appearance in this matter. I'd like to start with her and see get her perspective on this.
Your Honor, unfortunately, my part will be very brief. Only one side has paid my retainer thus far, Mom's side. I've still not been paid by Dad's side. I've also still not received any of my, I sent out a waiver and an engagement letter form for both parties to sign. Mother has completed those, father has not as of date. So I do insist that I be paid in full before I get involved in a case, especially one where it's a very active case. So I have done very little thus far. I have not met with my client yet. I can't give the court much of an update.
All right. Well, I understand where you're coming from. Any comments from Mr. Shattuck? I think part of the representation was that your client hadn't fulfilled his obligations to get Ms. Satterley on board.
For sure. I got an email from Ms. Satterley, and I recently responded and trying to confirm that she had been paid. She should have been paid some time ago. So this is news to me, but it will certainly explain why she hasn't engaged yet. So I will make sure that on Dad's side that gets taken care of right away. And I presume the court can allocate that cost hereafter once we determine the party's incomes.
All right. Okay. All right. Well, who wants to go first on any volunteers on who wants to go first as to your respective clients' positions on what the court, if anything, the court should be doing today?
Yeah. I think, Your Honor, it'd be appropriate for me to start off, and I know I haven't been involved as long as Mr. Swinyard, but long enough to get a feel for how things are going in this case. I think since the last hearing on June 1st, the court lifted the supervision requirement, and unsupervised parent time pursuant to 302 was ordered. So let's look at what has transpired, what's happened, what parent time has been taken. So right after that hearing, June 4th, Taylor chose not to take her parent time. We don't know why. We just got a message and she didn't exercise it. On June 5th, she took parent time, but started it 7 or 8 hours late and went through June 7th, that being her weekend. She also took parent time on June 11 and 25 from 10 to 6, even though she's entitled to 8 to 8:30, and then skipped the 18th and also the weekend of 19th through the 21st due to rehab or to the inpatient treatment of whatever sort she received. And then she also took her weekday parent time on June 25th and July 2nd, again from 10 to 6. So in summary, she took half of the weekends available to her, and she exercised 16 of the 50 hours available to her on the midweek visits. And so that's about 32% on the midweek. Overall, a little over 40% of her time she's exercising. The communications have been a little bit difficult. For example, when we learned of the inpatient therapy of some sort that she checked herself into, Dakota was parked at the parking lot waiting for the exchange a little bit before 10, texting with Aspen, who was providing the third-party transportation for Taylor, and asking if parent time is going to happen. And Aspen responds, "Oh, you reach out to your attorney." And mind you, this is like 10 a.m. 10:41, I get an email from Mr. Ficklin informing me of the inpatient treatment and at Alpine Recovery Lodge, and that parent time would not be exercised.
Okay.
Now, we should have maybe been notified before that, so folks aren't waiting around in a parking lot for no reason. Communication beforehand would have been much more helpful. After that, I think that the exchanges have gone fairly well for the most part. There was some confusion on one of them where counsel was requiring or demanding that Mr. Mortensen use a third party to meet with Taylor's third party, and ultimately law enforcement helped make sure that exchange took place since it was being refused, since Dakota was coming, as he always has, to these exchanges.
Was this the day that she said he appeared on the motorcycle?
Different date.
Okay, all right.
Yeah, different day. But I will speak to the motorcycle incident. I mean, it's interesting. A short ride on a motorcycle. Kid had a helmet. It is an e-bike, like a Suron type electric bike. Short distance. A helmet was provided. In fact, the helmet's in the exhibit picture. So it's strange that there was an insistence by Taylor that there's no helmet.
Well, the child is how old? 2?
He's 2. Yeah.
All right.
Yeah.
Well, we're not going to do that anymore. All right. That's one thing that'll come out of today.
Okay. Sounds like we got the partial ruling working already. All right.
Not with a 2-year-old. Maybe with a 12-year-old. Even then, there's no point in my view of, there may be some legitimate argument about whether or not that constitutes grounds for having him do a hair test, a drug screen, but as far as for basic safety, I mean, we generally require car seats or age-appropriate child restraints.
Fair.
All right.
Okay. Fair. Well, he will do that moving forward. He's gotten that from more than just Your Honor. So I think he'll be more wise in the future. I think he felt that the helmet was sufficient. It was, and with others, but nonetheless, we'll do that moving forward. Now, with regards to parent time, with Taylor only exercising a fraction of the parent time available to her, no input yet from Ms. Satterley. But I think more importantly, no disclosure yet of details about this inpatient rehab or documentation. I understand some papers were delivered to you this morning.
Well, I think there was a drug screen that she was willing to take, and from what I was reading, that may have come back. The results, Mr. Swinyard, did they come back? You're muted right now.
That's correct, Your Honor. That's one of the documents that was submitted today. When she had her brief stay at Alpine, she took a urinalysis test, and those results have been provided.
What was it screened? What was she? It's in the reports in the file. There's no way I could read all these documents today. All right.
I understand.
Yeah. All right. So where is that? Do you have a document ID number on that?
It is in the it is in the pocket of the binder. So this is the document that was submitted for in-camera review.
Do I have that? Do I have the binder? I don't have a binder.
Okay.
When was that delivered?
My office delivered a binder about 3 hours ago to your clerk.
Okay. Well, do you know where? Downstairs in the main clerk's office, or at
I can
W30?
I'll ask, Your Honor. I'll ask clarification right now.
Okay, let's go. So tell me what your representation would be. You're saying it came back negative. I'm asking for what it was screening for. 5-panel, 10-panel?
My client recalls it being a long list. She estimates a 10-panel test. And
All right,
it came
we'll
back.
see what that says.
They did a medical review as well and confirmed that the substances detected were consistent with her prescribed medications and nothing else.
All right, I'll just wait. Well, I need to see the verification on that. If you have it, you can upload it into the court file as a separate document during the hearing if you like.
My assistant just alerted me it was the main clerk on the first floor of the courthouse, so not at your actual courtroom.
Why don't you call down to the protective order office?
Your Honor, I would like to have the opportunity to see that as well.
Yeah, I would too. Okay. All right, so let's come back to you, Mr. Shattuck. You can keep making your argument.
Thank you. I think in light of the parent time that has been exercised in part only by Taylor, it wouldn't be appropriate to expand that just yet. But we've also been seeking and asking for documentation about this inpatient treatment. Maybe what's been delivered to the court has something to do with that. Again, counsel indicated he got documentation from Alpine like 3 weeks ago, and or 2 or 3 weeks ago. My 3 might be a little far, but I haven't seen anything yet. He did email me just a couple hours before this hearing, giving me the opportunity to come to his office and look at them. And in light of the hearing, I don't have time to go spend the hearing with him, but rather would like to see what's been provided and really looking for just a verification that nothing is going on that's being hidden. I mean, I don't know why it was mischaracterized to me.
I think this about it. I mean, there could be some privacy issues when it comes to medical records. I mean, on the one hand, on the other hand, it may be fair game where custody and parent time issues are before the court. At the same time, it might be appropriate to have, if we don't already have in place, to have a discovery protective orders in place, limiting dissemination of documents, and perhaps even that they can be viewed only by counsel and copies not be provided to the clients. That if the court is reviewing them, that they happen in camera and not filed with the court, like with the mental health evaluations, those kinds of things.
Certainly open to that,
Right?
Your Honor.
Especially with a case that has garnered this much attention.
Yeah. Speaking of that attention, we've been a bit dismayed that Taylor continues to make disparaging remarks about Dakota online. Dakota's not doing anything online, no social media posts or anything, and we provided the court with more than a dozen examples, one of which she alludes to she might be killed, and just nonsensical stuff that should not be happening. And I think it would be appropriate for this court to order both parties to make no communications with media or on the internet, social media, about the proceedings and about each other, because it just fans the flames of the dispute between these parties when we got third parties and friends who are seeing things, and that comes back, and this thing can just spiral out of control. And I think that the parties need to exercise better restraint.
So I did make some commentary about this at the last hearing. I know you weren't here at the last hearing, but I indicated that I was not really of a mind to restrain either party from their free speech rights on the one hand, but when it came to derogatory comments about each other, that's where I was drawing the line, because that can affect the child. And so to the extent that they weren't already in the orders, it would seem appropriate, and I do want to give Mr. Swinyard the opportunity for argument as well, but as an initial matter, it would seem appropriate and that it's fairly standard to issue orders restraining the parties from making any denigrating or derogatory remarks about each other directly to or in the presence of the minor child. And that can include social media, and it would also to extend to the parties encouraging third parties from engaging in the same kind of behaviors. And if they don't have control over that, then to remove the child from that environment. But I'm not inclined to just say they can't access media. These are people that have monetized their private lives and become a part of popular culture. And that's not really where I'm headed with this. All right.
Lastly, Your Honor, I think it'd be appropriate for the court to provide some clarifying order regarding the parent time exchanges. We've offered to perhaps have Taylor use a third party in the morning, because sometimes she changes her plans last minute, and that might be easier for her since she's got a larger support system with Family Local. And then Dakota could provide the third party in the evening, and then they can individually be present when the other party's third party is there for the exchanges. And that way there's no confusion, there's no insistence on third parties being there when that hasn't been ordered by the court, but some clarity there so we can avoid
I think what I said, that either party could bring, you may want to remind me, Mr. Swinyard, too. I may have to go back and look at the other case because this is the first hearing we're having in the domestic case. But I thought that I was authorizing each party to bring somebody with them. But it also, we had mutual protective orders. So it would also be an indication that maybe I wanted it to be through a third party.
I think you used the
I
word
can't
may.
remember what the order said. Yeah.
I think you used the word may, and I think with these two parties, we probably need a more firm directive because Dakota wanted to maintain the status quo of him always going and having exchanges with Aspen or
All right. What's his position on that again? He wants to do what?
Have her provide the third party for the morning exchanges, and he'll provide the third party for the evening exchanges. That way, hopefully, have a little more advance notice so he can make arrangements because he has less people to pull from.
I see. So yeah. Mr. Swinyard, let's hear from you on that.
Sure. Just on exchanges for now, or do you want me to?
Just on exchanges. Yeah.
Sure. So I think we can reach a stipulation that part of the issues that have been coming up over the last few weeks relate to whether Dakota has to provide a third party at all, or if Taylor is the one who uses a third party for every exchange, both legs. And we don't think the latter scenario is fair. It makes sense. What Mr. Shattuck just described makes a lot more sense than what Dakota's insisted on recently. The court's order from the June 1st hearing does leave a few things open to interpretation regarding this, but we absolutely think they don't need to be around each other at all, even if a third party's present.
Well, that's one of my huge concerns, right?
Sure.
Is that the fireworks won't take long, right? Okay.
So there was 2 days after the June 1st hearing, there was an agreement between counsel, between our office and Mr. Shattuck's predecessor, that the receiving parent would provide a third party to facilitate the exchange. And it's been difficult to get Dakota to follow through with that. But I think that with his acknowledgement today, with his stipulation today on the record, that is a big piece of the puzzle. And so either sending the third party, my client sending the third party in the mornings and Mr. Mortensen sending his third party in the evenings, I think that'll be very helpful.
Okay.
Doing the exchanges either at the parties' respective residences or the Smith's parking lot should be adequate as well.
I think that there's, given the number of declarations in the file from their various support people, that there's a bit of polarizing going on in the sense that it may be hard to find somebody who's not going to be taking sides during these exchanges and then trying to be a witness. And I'm certainly okay with either party bringing somebody with them if they want to. The bigger question was, should either of them be involved in actually handing the child off from one to the other, where they're in close contact with each other? Because I do think it's okay to record if that's what they want to do in case there's allegations that are made. But I did not want any third parties to be interjecting themselves in any way, effectively remaining silent and observing and not becoming an active participant, except maybe where it may be hand-holding from one car to the other, because we have a 2-year-old. We can't, maybe Ms. Satterley can chime in on this in general, not even having met her client. I mean, the dynamics here are such that there's mutual protective orders, so they're not supposed to be within a certain number of feet of each other. Yet we also have a 2-year-old child who probably can't just walk from one car to the other with that kind of distance. And then there's certainly allegations are arising there's new allegations, another new police report from June about I believe it was an issue concerning whether a private investigator was involved in this case. So there's just given the nature of the dynamics, what makes the best sense. I'll come back to you on that. Maybe give you some time to process that while we're talking. Okay. All right, Mr. Shattuck, anything further?
I think briefly on the exchanges, I think we'd prefer they stay at a mutual location, a public location. The Smith's parking lot has been working fine. We'd like that to continue. May
Okay.
prevent the possibility of some issue happening.
Okay.
And in brief, we think that, there needs to be more clarity, more disclosure about whether or not Taylor's in a spot where she should be expanding her parent time. But I think she's demonstrated with her choice to exercise less than half of it that she's probably not really got that as her priority. And we think the court should leave things in place as currently ordered until we get a report back from Ms. Satterley and
Well, yeah,
documentation
but
on
here's
her
the problem with
treatment.
that. All right. If Ms. Satterley isn't getting going because your client hasn't paid the fees and hasn't signed the paperwork, that's problematic. If you're just saying we need to hear from Ms. Satterley before we consider expanding parent time.
Well, I'm going to insist if there's documents he hasn't signed yet that should have been signed, I'll print them now and have him sign them while he's sitting here. And we'll get
Please.
this process rolling. So I'm not opposed to that, Your Honor. And even without input from Ms. Satterley, a conversation with a 2-year-old is going to be pretty limited. I think that what the parties have done is really what the court needs to look at. What we choose to do with the time available to us should tell the court the story the court needs to see to determine if it's right or not to expand.
All right. All right. Let me turn to Mr. Swinard. We'll go back and forth here a few times. All right.
Great. Your Honor, I'll jump right into rehab if that's okay, or this stay at, more accurately, this stay at Alpine. The dates were June 19th and June 20th, so 2 nights. And the purpose, as she's disclosed to counsel, was a professionally supervised transition to new mental health medications. She wasn't sure if there'd be a negative reaction, so she wanted professional support if it ended up becoming necessary. She did wait until after the June 18th visit, so she wouldn't miss that visit. And
so are you saying she was feeling like the meds she were on wasn't working that well for her anymore?
Yeah, she wanted a change.
Yeah. Okay.
She wanted ample support in making that change and making sure that it unfolded appropriately.
So when she checked in, was she under a care of a psychiatrist during that weekend? Those couple of days?
Yes, there was a team at Alpine and there's a psychiatrist on team on
Okay.
on staff.
All right. Okay.
She also timed it around Father's Day to a weekend that would be spent wherever would be spending with Dakota. So she's trying to minimize the disruption to her parent time. That weekend would have ordinarily fallen on her rotation, but she scheduled it that way.
Let me ask this about it. Are you saying that she wanted to be under observation in case there were negative reaction to the new cocktail, shall we call it, of meds that she was being prescribed?
Just to help you understand, it is like with switching meds. Yeah, I wanted just like some extra help, like if there was a reaction, and then maybe like to try
Okay.
one, and if it didn't work, then to have someone just like recommend another one. So just honestly a reset and help with that.
All right. Okay. All right. I hear your position on that. Okay.
Counsel was informed, and he did request documentation, but in this case, Your Honor, you are very familiar with this record, and you probably recall the all too familiar leak pattern in this case, or someone tipping off or leaking information to the media. And my client had some real concerns about this, and it didn't take long for those concerns to be validated. Dakota's roommate and very close friend, Mr. Eaton, has been actively posting online about my client's treatment, including even making a false allegation that it was involuntary.
Well, here's what I would say about that too. I mean, if the parties are restrained from making negative statements about each other, I mean, this is the difficult part with this case where there's so much public interest, right? To what extent do they have control over third parties? Now, if we're talking about one's best friend, there could be a argument perhaps that they're acting on behalf of the party who's restrained, and that could theoretically be a violation. And I think there's probably some argument that's being raised about whether or not having a private investigator follow somebody around could be a violation of the protective order as well. But it's the way I'm looking at it today is if there's a belief that there's a violation of orders, or if you believe that we need to have specific orders, I'm willing to hear what that is. If it's a violation of an order, I think that's going to require a motion to enforce.
Understood. And the reason I bring this up, Your Honor, is to explain my client's hesitation to just turn everything over to Dakota. She had some very real concerns that have been, unfortunately, repeatedly validated over the last 3 months by Dakota about his discretion in holding on to and keeping that kind of material safe. So we've proposed different ideas here, including potentially allowing a neutral professional to review those documents. My client underwent a drug test at Alpine and has even offered to take another one and has taken one. She took that at Fastest Labs on the 6th, a nail test, a PEF test, and she's awaiting the results, and those will be released to counsel as soon as they're back.
Okay.
We're also
Well, and that was offered in the matter with Mr. Paul, right?
Yes, that's correct.
Yeah.
That's correct. The court, at some point today, I thought you would have it, but it sounds like there might just be a disconnect between the clerks, which is okay.
I have it now, the
okay.
binder. Yeah.
So in that binder, there is that 3 pages from Alpine, which counsel is welcome to review. At this point, we would ask.
Did you not forward it to counsel before you gave it to me?
That's correct. But I did offer the
Let's
chance
be careful about me looking at it then first. Let's have
and that's
a
completely
conversation about that.
That's completely fine. I actually don't care, frankly, if the court reviews those documents today or not. The reason I submitted those documents is because I don't want the court to rely on conjecture, the smoke and mirrors that Dakota has to rely on. Well, she checked into a facility and she wasn't perfectly forthcoming with us, so it must be drugs, Your Honor. She's hiding something. And we don't want to be in a position where the court feels that it can rely on that. And so if the court is giving no weight to that, then we're fine if the court disregards those records for the time being.
I'm just want to be clear that there is another dynamic at play here, which is everybody's highly suspicious of each other. And anytime there's blanks in information, the tendency is going to be to assume the worst. All right. So from my view, more information is better, but I also understand the concern about it potentially being disseminated and getting out to the public, such sensitive type of information.
We're trying to thread the needle, and we think, there are some options at the court's disposal that allow some transparency without something terrible happening, like a disclosure of this information. So that's what we're trying to implement here. And I appreciate the court's understanding of that.
I mean, there is a bit of an irony in the sense that they're public figures and they want privacy at the same time. So, yeah.
Judge Mal pointed that out as well. I understand. A few comments regarding PCIT, Your Honor. This has been alluded to in Dakota's status update, and I just wanted to provide the court with an update here. The court's June order compels the parties to comply with DCFS's therapy recommendations, and that includes both EMDR and PCIT. DCFS notified us that they expected the parties to proceed specifically with PCIT. So PCIT was the exact designation used, not some other label.
Right.
Dakota, at the previous hearing, you may recall, proposed using the Children's Center, and we did not have an objection to the Children's Center. My client gave her authorization to the Children's Center after the June 1st hearing, and surprisingly, verbal consent is sufficient to begin that process, which she provided weeks ago. They did later request a written consent form, which she immediately provided the day after the Children's Center sent it to her.
Is this a complaint about something or just giving me information?
It's giving you information because Dakota's alleging that it's being stalled, that we're holding things up. And so I'm just providing the court with some background here.
Okay.
And my client has an appointment scheduled with their clinician today, in fact, this afternoon.
What's her response to the allegation that she hasn't been exercising all of the parent time that she's been awarded up to this point.
Sure. Well, there's a few things that came up immediately. I mean, you may recall at the hearing from June 1st that I requested that the weekend rotation commence that weekend. And it turns out I spoke out of turn. My client did have a scheduling conflict over the weekend. And so that same day, the June 1st, I asked counsel, once I learned this from my client, I asked counsel, Mr. Shattuck's predecessor, if we could switch the rotation so she could still have her parent time. She wouldn't have to reschedule. Figured that would be fine it would be a reasonable request. But the request was denied. Once the request was denied, my client was able to reschedule her obligation and took that weekend with Ever.
Okay.
As far as the June 18th visit, Dakota almost alleges that the June 18th visit was missed. It wasn't. I mean, in his declaration, he kind of leaves it off. He says, well, there was a miscommunication with the exchange person, and he's implying that it didn't take place, but the June 18th visit did in fact take place. June 19th, again, that was a shortened weekend for my client due to Father's Day, and that's why she structured it there. So she did miss the evening of June 19th, or the overnight of June 19th.
Okay.
So,
I have another question too. If the judge grants the motion to set aside, if Judge Mao grants the motion to set aside, is it anticipated that we're going to be looking at a custody evaluation?
procedurally, I haven't gotten that far with my client. I know
All right.
that hypothetically that is a possibility. It's also possible that now that we have a private guardian ad litem, well, once Dakota pays, we'll have a guardian ad litem plugged into the case. Some folks see a custody evaluation being a bit excessive. When you have a private guardian ad litem, there's different opinions on that, but I don't have a great answer for you at this point, Your Honor, as far as that hypothetical scenario.
Okay. All right.
Few points on this police report, if I can, Your Honor. This is our Exhibit C that's in front of you. Dakota is, and this is part of our broader concern, he's using the exchange process. He's using the protective order. He's using this unusual, by their historical standards, custody arrangement to exert control over my client. And
In what way?
He's using police now to do this. And I have multiple concerns and observations about the report.
Well, this was the one where it turned out to be a private investigator. Is that the one you're talking about?
Our Exhibit C has nothing to do with the private investigator. Our Exhibit C is Dakota's recent call to police because he claimed that Taylor was violating the protective order by Aspen communicating about parent time related issues. If you look through Exhibit C, you'll find a few strange things. There were
the one that I'm looking at ends in 2930, 226 BD 02930. Is that the one?
Yes,
Exhibit C?
that's
Okay.
our Exhibit C, Your Honor.
At June 26th, this was what? Last
That's
week?
correct.
Or the week
Very
before?
recent.
Yeah.
That's correct.
Okay. What
So
happened? No.
if you look through the police report, one thing that stood out to me as a bit unusual are 3 separate calls between Mr. Shattuck's office and law enforcement, including an explicit demand from Mr. Shattuck's paralegal that law enforcement arrest Taylor. It is unusual for a law office to step into that role and badger law enforcement to arrest.
And where am I looking here? What page?
Sure. Let me get that for you, Your Honor. This begins on page 4. 4 of 11.
4 of 11?
Top right. Yes.
And who's Katie?
Katie is Mr. Shattuck's paralegal.
Okay. So that's your investigator, Mr. Shattuck? Katie?
Well, that's
No, Your Honor. Katie's not an investigator. The AI report is in error that way. Bluffdale's going to issue a revised, corrected report because she never held herself out as an investigator. She is my paralegal.
Okay.
She did call the police because of the violation of the protective order having a third-party stalk Dakota.
That's odd that a paralegal from the attorney's office would be the one to call the police, but okay. So let's hear what you have to say, Mr. Swinyard.
sure. I find it odd as well, and I found it even stranger that there was the demand to arrest her, and I just think let law enforcement do its job. On page 8 of the police report, you'll see that Dakota told law enforcement that because a guardian ad litem was not in place, all communications had to go through counsel.
This is the issue where I think it was her sister that had been calling to try to facilitate the parent time. And,
texting. Yes.
Yeah, texting. Okay.
Yes. And they are allowed to do that under both parties' protective orders, because remember, there's identical protective orders here. Under both, they are allowed to use an agreed upon communicator, which they have been doing since entry of the protective orders.
Where does it say that the paralegal was demanding that Ms. Paul be arrested?
There's reference to a mandatory arrest, and I will get that for you in just a moment. It looks like it's on page 5, Your Honor. Final paragraph.
Okay. All right.
Additionally, Your Honor, this could have and should have been avoided. One is Aspen is allowed to have those communications. And from the police report, it's very clear that very selective information, very carefully curated information and communications were provided to law enforcement. Only the texts from the very recent exchanges, totally out of context. It looks like nothing historical was given to police that shows that they actually did have an agreement by practice to use Aspen regarding parent time issues. Our Exhibit B in that binder in front of you, Your Honor, is 28 pages of communications between Dakota and Aspen since April 10th. And
you wanted me to go through all this now?
no.
Okay, I
take it from me, Your Honor. These messages are boring, which is the nicest adjective I can use in a case like this. These are exactly what we expected and wanted them to be.
All right.
They include everything from when parent time should take place, specifying length and days of parent time, where to meet, whether Ever had eaten recently, whether Dakota had sent shoes with Ever, because apparently he had forgotten, whether Ever had taken a nap, rescheduling parent time, Ever's sickness and mood, Ever's size of shoes, discussing doctor's visits and medicine dosage.
Usually I see these when there's something that you want to point me to that is a so-called smoking gun.
When I'm pointing
something
you to
that the other side has said that you've documented that you want me to take into consideration.
It's the reverse here. I'm showing you a lack of smoking gun. And what I also find interesting is Dakota put himself in a very difficult position, with law enforcement. I actually don't consider Dakota's communications a violation of the protective order, and I would never advise my client to go on a quest with law enforcement to badger them into submission to pursue charges against Dakota, and I certainly wouldn't take that.
Well, I don't know that I read into it as much as you do. I'm looking at it and said the paralegal is simply advising that the law says this.
Understood. I think the broader point here is Taylor did not violate the protective order, but if she did, then Dakota did as well. And counsel talks about exchanges going well. They're not going well. They could be going a lot better, and I think they go a lot better if we could cool it on the calls to police when those calls don't serve a purpose. It's been completely unproductive for him to engage in this. There's no reason to call police here.
So what are you asking?
For the court to take note of that, for the court to take note of Dakota abusing the current dynamic and improperly attempting to exert control over the situation over Taylor.
Well, how does it tie into what I should be doing, if anything, today with respect to parent time?
Sure. I think restoration of some normalcy is what we need. And I think that, again, this current situation.
What's normal? I guess that would be
it's a fair question.
Good question here, right?
Well, according to the parties themselves, as of last August, what normal was written in a stipulation.
All right. Okay.
So that is our request. I do have just a couple minor points, Your Honor. I know we are moving through this quickly, and I appreciate that.
Well, I try to schedule these as my last matter of the day, knowing that they may go on for a while.
Understood. There is And I know the court's already addressed the private guardian ad litem, and you hit the nail on the head regarding Dakota's very unfair request today of, well, Ms. Satterley's not fully plugged into the case, so the court's hands are tied. I think that logic speaks for itself here, considering his lack of payment. There is an interesting connection to.
Well, let me just see this. When did Ms. Satterley, did you entered an appearance because you're attached?
Correct, Your Honor.
So you appeared, it looks like, on June 13th. So it's been close, well, it's been 3 weeks, more or less.
Correct.
Okay.
Within 5 days of getting my order of appointment, we are supposed to do a notice of appearance. I emailed all counsel on June 16th with my engagement packet. I then emailed Mr. Shattuck again on June 24th and had communications with him yesterday.
Okay. All right. Well, and despite that too, I just want to say, I mean, I do have some concerns, and I see this in a lot of cases where custody is in dispute, that we have a lot of hearings that are the parties jockeying for position as it gets closer to trial, with the belief that the status quo may prevail by the time they actually get to trial. Don't know what to say about it other than that. There may come a point where I just say, I'm not going to make any more changes, get it to trial, and let's get it resolved. But I also recognize that there may be a lot of discovery left.
Sure. And I understand that dynamic as well, Your Honor, but my client's main concern today is not really trial position or anything along those lines. It's just getting more time with her child. There is an interesting connection between the guardian ad litem transition to this police report. Dakota did argue to police that because there was no private guardian ad litem in place, all communications had to go through counsel, and that's noteworthy for a couple of reasons. One, it's not correct, but also I think it does provide some explanation as to why Dakota still has not paid the private guardian ad litem.
Has your client been exercising midweeks as well?
Yes, she's been exercising midweeks, Your Honor.
All right. Okay.
Couple just final points, Your Honor. One is, I mean, I think the picture should speak for itself.
What picture?
This is our Exhibit D, Your Honor, the motorcycle picture, and the court's already seen it. But counsel states that's a helmet. Okay, it could be. I don't.
Well, I've already ruled on that today. We're not going to do that in motorcycles anymore. Nothing with anything less than 4 wheels. Let's put it that way.
Understood.
All right.
I do want to point out, though, a couple of corrections. This was not a short cruise down the neighborhood street. This was almost 3 miles away from Dakota's home, either via Redwood Road or Bangerter Highway. I certainly hope he didn't take Bangerter, but Redwood Road is not much better. It's an extremely dangerous road. It's a full-size motorcycle, as you can see from the picture. He's taking it on highways with ever, in traffic during rush hour. His feet don't come close to the footrests. I think this was a terrible lapse in judgment on Dakota's part, and I think the court should take note of that. As far as this court's concerns regarding social media use, I mean, obviously the parties have some pretty substantial, very important First Amendment rights, heightened by the fact that they both have an important platform here that they can use to educate the public. My client has taken social media herself. Dakota instead uses third parties. Through Crew, his very close friend and roommate and active documented participant in this case, he has leaked even more videos, or one video in particular from a few days ago that until a few days ago was not known to the public. It was a private exhibit in the parties' protective order actions. It was it's a brief video of the parties' altercation, of them having an argument back in 2023. The intent was obviously to embarrass Taylor.
They have to be, I mean, as you know, I mean, in not just limited to this case, they have to conduct themselves as if they're being recorded at all times, because it may end up as potential evidence in court. It's hard to say that, right? Behave in a way where you have to assume you're on camera 24/7, especially if they both have, or one or both of them have investigators involved. And so I will say this, as I indicated, I wasn't necessarily going down the road of restricting them from any social media postings, that doesn't mean that there isn't a reason to question the wisdom of engaging in social media postings.
Understood.
Right?
Understood. The reason, again, I bring it up is, I mean, there are, the court has to be mindful, which I think you are, Your Honor, of the fact that someone can engage with the media, including social media themselves directly, or they can launder those communications through third parties, which is exactly what Dakota is doing here. And this is not some distant person who randomly got their hands on something and went rogue and posted it themselves. No, this person resides with Dakota. He's an active participant in the case. He's very much aligned with Dakota, which is fine, but he cannot be out there. Dakota cannot be out there using this individual to leak information and potentially try to embarrass my client.
All right. Okay.
So as far as just in conclusion, Your Honor, we are asking for reinstatement of parent time based on the party's August 2025 agreement. His failure to pay the guardian ad litem's fee is, we believe, a delay tactic, so she doesn't receive an increase today. She has been the primary historical caretaker of Ever. He's asserted to the contrary. There's just no way he can prevail upon that, at least up through last fall.
That might require a full evidentiary hearing if there's that kind of factual dispute. So,
understood.
Yeah.
He did have only a handful of overnights with Ever until last fall. Since then, it's been more shared, more in line with that stipulation I mentioned. And Ever, 2-year-old Ever, is still experiencing emotional distress because of these short visits, the transition.
Well,
We are asking.
I keep trying to hammer home the point of getting these folks to work it out between themselves. That's the best way. If you were talking filing motions to privatize and keep the media away, best way to do that is to resolve it on your own. But if you can't do it, that's what we're here for.
Music to my ears, Your Honor. The last thing I'll say is, just in interest of returning to normalcy here, the court has expressed concern in this case, or the protective order case, at the conclusion of the April 30th hearing, that there could be a power imbalance, that Dakota may use certain restrictions to impose his will on Taylor, including issues such as supervisors at the time. And I think we are seeing that play out with crying wolf to law enforcement, of reneging on agreements related to exchanges, on being too restrictive on
Well,
parenting.
I don't know. I mean, making false allegations to police can be a crime as well. So if he's going over if he's crossing the line there, he may be exposing himself.
Understood.
At least I can't stop people from calling the police. Certainly if you have a series of police reports that's, I concluded there was no violation of the law. This one at least said that they didn't believe there was a basis to make an arrest. I don't know if it's being screened or not. But typically we don't get into violations of protective orders when we're just trying to arrange parent time.
Understood.
Yeah.
I think I bring that up to illustrate that it's not working very well. Dakota is unnecessarily ratcheting up pressure and trying to intimidate my client. And I think that a more normal schedule will make more sense, as opposed to the statutory minimum. And so that's all I have for the court,
Okay.
Your Honor.
All right, let's go back to Mr. Shattuck, and if need be, I'll come back to you again, Mr. Swinyard, and then I'll make some rulings.
Thank you, Your Honor. At the June 1 hearing, Your Honor recognized that there were no current financial declarations and found that the parties needed to submit those in order for the court to determine the allocation of the cost for the guardian ad litem. And my client did that on June 5, and then the deadline was June 15. We finally got Taylor's on June 29, and awaiting that allocation was also part of why Ms. Satterley wasn't retained. We didn't know which portion the court wanted us. We're going to move forward with the presumption that it's 50-50 for now, unless you order otherwise. But having no direction from the court other than that it needed to make that determination we figured that it also hadn't been done, and we needed to
No, no, no. I'm not, that doesn't fly with me. You know, we had an order in place that said for now it was 50-50. It can be reallocated
Oh,
at
did it say
a
for
later
now?
time.
I'm looking at it. I didn't see it 50-50, but if that's what you're saying now, we'll accept that. But the order doesn't contain that. But nonetheless, we've had Dakota sign the paperwork here today, and we'll have her paid.
Here's what the order says. If I'm wrong about this, I'll stand corrected. But what it said, 50-50, 1,500. So $200 an hour, 1,500 retainer, split between the parties 50-50. That's all it says.
Is that your appointment order?
Yes. That's docket number 70 in the file, signed by me on June 9th.
June 9th. Okay. Okay. I'm sorry. I wasn't shown that. Nonetheless, we'll have her involved right away. I think most importantly, the court indicated on June 1st that Your Honor wanted to see what parent time gets used, to see if Taylor's exercising what's been given her, so you would consider possibly expanding it. And we've seen that she does exercise less than half
That
of
was mainly what I was expecting this hearing to be about, whether we were expanding parent time, adding restrictions, or doing nothing.
Yeah, that's why I remind Your Honor about that being your focus. And she clearly has not been exercising what's been given her, and it would be inappropriate for the court to expand further if she's not using what's already been given to her. Now, the council argued a lot about this June 26th police report. Certainly, we're going to see how it's clarified once they get the real report and the AI one is replaced. It's not unusual for a law office to be involved when a protective order is violated. And so that's why my office was.
It's a little odd to have someone from your office be the one to make the phone call, but I don't know that I've never heard of that before, but that's all I can say, right?
Well, it's either you instruct the client to call, which is typically what happens, or
typically they're calling on their own.
Typically.
Right. Yeah.
Yeah, typically. But I don't think it's per se wrong for anyone to recognize a violation of an order and to make it known.
Okay.
Now, the timing of this inpatient therapy is very telling. Counsel's argued, I think, 3 times that Taylor carefully planned to have this therapy or this inpatient from the 19th to the 21st during a time that wouldn't interfere with parent time. Well, how about an off week or Monday through Wednesday, any week, instead of on the day she's supposed to take parent time and without almost any warning? So it is highly suspect that perhaps it was some immediate need or some mental health issue. We don't know yet because we haven't seen any documentation. And so I think it'd be premature for the court to make any changes.
Well, I do want you to be able to look at it, but I don't want you to be able to disseminate that information. All right. So I talked about, and I want that to be part of the order today, that we have a discovery protective order case. You probably both have standard language. Why don't you can compare that language and see if you can come to an agreement as to what that should look like. But typically it would be for attorney's eyes only, in the sense that, well, let's put it this way. The clients could also look at it, but I don't want it to be disseminated to either client, except she already has a copy. It was her report. I don't want a copy in Mr. Mortensen's hands of her records, nor do I want her to have in her hands copy of his records. All right. But I do think they should be able to look at it. I mean, I think that's important for strategizing and whatever else there may be, concerns that may be raised on the one hand. But again, my concern is making sure that it's limited to the use in this case and that it's not being disseminated.
Okay.
That it can fall into hands that might end up. Now, it can be certainly problematic as well if one of the parties is leaking information to the media. I think that's probably a good restraint to have as well, that the parties at least be restrained from doing that. Now, given the history of this case, I've also, I've seen that some information may get out anyway. Let's just put it that way. I mean, it is an open hearing. There are grammar requests that can be requested by media, et cetera. All right, I'm sorry I cut you off.
Your Honor, I think I was about done there with my response, and so I'll go ahead and just let me just check my notes here. Oh, yes, a couple more items. You know, the third party communication to coordinate parent time shouldn't be negotiating parent time or negotiating terms, and that's part of why there was an issue with some of these communications. Dakota didn't leak the domestic violence video from 2023. Many
I know.
people.
I'm sorry, you're saying he did or he did not?
He did not.
Yeah, I know. I knew there was a factual dispute about that.
Yeah. Well, and my point is, counsel keeps alleging that Dakota's leaking. He's not. He's not the one posting on social media. Taylor is, and so you know we're abiding by the rules, and she's still disparaging. I don't want to waste time on motions to enforce. We may have to, but you know, I think it's important, and I would ask the court to, you know, instruct the parties not to disseminate. And I think you've already indicated you're reluctant to do that, do their First Amendment rights.
I don't want them to disseminate information like that's being used in the case. I just don't think that's a good idea. All right, that's so they show up to a parent time exchange, for example, and it's being recorded for protection against false allegations, and then suddenly it's online, right? I don't want them posting about each other online.
Okay.
But if they want to post in general, I don't have a problem with that. I just don't want them disparaging each other. I don't want them to be posting videos of each other. I mean, how detailed do I need to get with this?
Apparently very, but we'll put that in the order, Your Honor, that you don't want them posting about each other online. And I'll defer for your ruling, Your Honor, on the remaining issues.
All right, Mr. Swinyard, anything else from you?
Only a couple things. I think Dakota's, by pointing to the private guardian ad litem order, well, we don't know how the court was going to allocate it. I think that's a new reason that he's giving today. I think the real reason that, based on counsel's opening comments on this at the start of the hearing, was that it just slipped through the cracks. So that happens. Yeah, but I think that's the real reason it slipped through the cracks. It's also possible that there's some intent here to stall the proceedings and limit Ms. Satterley's voice today.
Maybe it was just but I am concerned when I hear from Ms. Satterley about multiple communications and it's still not done by the time of hearing.
Right, I was as well, concerned and frustrated. As far as the visit to Alpine, in hindsight, it was a 2-night visit. She could have structured that around parent time with 0 interruptions. But what I alerted counsel to is that she was budgeting maybe up to a week, not really knowing exactly how long it would take. And she checked out voluntarily after 2 nights. So just wanted to clear that up.
Did she miss parent time as a result?
There was one parent time slot that was missed, and it was a shortened weekend because of Father's Day.
Was it conveyed to him in advance so that he wouldn't just show up and be waiting around for no reason?
It was conveyed to him at the start of parent time. And so I concede more advance notice would have been appropriate, Your Honor.
Sure. Yeah. And we'll have that in the order too. How about that?
No objection, Your Honor.
All right.
The last point I'll make regarding co-parenting communications, again, I don't understand Dakota's crusade on this point. If the court reviews Exhibit B, you're not seeing negotiation. You're not seeing a violation of the protective order. You are seeing both Dakota and Aspen engaging in voluntarily engaging in routine parent time related communications. He's been doing this for 3 months. And then on the figurative eve of a parent time review hearing, he tries to spin this by giving very limited information to law enforcement to try to bolster his case today. Oh, it's a violation of a protective order. I mean, don't worry about the history here, officer. Don't worry about the actual historical communications between Aspen and Dakota. Just take my word for it. This is an arrest.
It's a fairly lengthy report, and I think that the police have been involved enough between these two. This is Draper again, is that right?
This particular report is from Bluffdale PD.
Bluffdale, Draper. I mean, I think they're aware of the history at this point.
But there's no way they're going to be aware of the historical communications, the 28 pages of communications between Aspen and Dakota, which should have, in all candor, had been presented to law enforcement so they could review everything to understand if there really was a violation. And I think law enforcement will get to the bottom of it and come to the correct conclusion here and determine there was no violation. I just find it strange that he's pointing the finger at Taylor when he engaged in the exact same conduct, even referring to Aspen. He's talking about you guys, or he's directing multiple messages to you guys or to my client on parent time related issues. So I don't, again, at this point, I think he needs to be more careful and use better judgment in when he calls the police and launches an unnecessary attack on my client. There's just no reason for that here.
All right. Well, I think that certainly if the police determine that there's a false report being made, that's going to be an issue for him or for whoever's making a call to the police. But I don't think I can restrain a party from contacting the police if they have a good faith belief that there's been some sort of protective order violation.
Your Honor,
It
I do have
turns-
one quick question. I think for the benefit of both
Unless-
parties.
Go ahead.
Thank you. I wanted to make sure we had your thoughts on this or direction. My understanding is if either party is to use a third-party detective or private investigator or someone to stalk or to follow, that would be a violation of the protective order.
I don't know if that is. I don't know that that's a violation of the protective order,
So
honestly.
that would be acceptable.
Yeah. I mean, I think that there's, but I would want a motion on that and have an opportunity for that to be briefed, and because there may be provisions in the code that need to be addressed.
Oh, you'd want a motion before someone
Yeah,
does?
for example, if someone uses a private investigator, does that constitute stalking, right? And I think the statute may have something to say about that.
Okay, if we choose to go that route, we'll file a
Yeah.
motion about it beforehand.
All right. So let me make some recommendations for today. One is I do think that if there's not going to be exercising parent time, that there should be some communication beforehand so that people aren't unnecessarily having to waste time, for lack of a better way of putting it. I already indicated I don't want the child to be transported on a motorcycle. I want it to be in an enclosed vehicle with full safety restraints, age-appropriate child safety restraints. My recommendation further would be no online postings about each other, in the sense of making no denigrating or derogatory remarks about the other party directly to or in the presence of the child, and also in general in public forums such as social media. That doesn't mean they're restrained from posting and being a part of social media. I think that's part of how people were making their living, in fact, in this matter. TikTok, Instagram, that sort of thing. And but I want to draw the line at when it comes to making negative statements about each other. Eventually, all this could come back to the child, and this is where we're trying to shield the child from this conflict, even later on down the road, many years down the road. Next is I'm not really going to make changes to the order today when it comes to third party presence. I mean, it sounded like there might have been a stipulation on that, Mr. Swinyard. I think either party can bring somebody with them if they want to, but the responsibility to have a third party there for effectuating the exchange would be her in the morning and him in the evening. Is that what we were talking about?
That's
Or
correct. And I want to make
the parent, why don't we put it this way? The parent that's retrieving the child would be the one responsible for having the third party with them to facilitate the exchange.
yes.
Does that work for your client too, Mr. Shattuck?
Yeah, that works.
Okay. All right.
I do want to make sure that we're not expanding that unnecessarily. believe the court would have power to make a carve out in the protective orders to allow the parties and third parties to be at exchanges, but we're not requesting that at the moment.
I
We
just don't want them to be alone at the exchanges so that they have to do it themselves, because I want them to stay away from each other. And I want them, I want there to be at least one, I want there to be one person there to facilitate the exchange, but not to stop the other party from having somebody else there too to document.
Your Honor, I just don't want Dakota and Taylor at the exchange together, even with third parties there or not. If the
Oh, I
receiving
see.
parent,
Okay,
the
if you want to
receiving
send
parent-
somebody and not appear to do the exchange, that's
Exactly.
fine too.
I would
Okay.
not like these folks.
But the parent who's responsible to have the exchange person there will be the retrieving parent, not the relinquishing parent. All right?
Yes.
All right.
Great, thank you.
And we're still going to do that at the Smiths, right?
Yeah.
I think she's open to either Smith's or personal residence since we're using third parties, but we can work that out with counsel. I think we've come to the
Okay.
bulk
In
of
the
this.
absence of a stipulation, we'll just keep that at the Smiths for now. That's where it's been happening, right?
Great, thank you.
All right. And then I talked about a discovery protective order. I do think that's appropriate because we're dealing with some sensitive documents here. And then the PCIT therapy that you brought up, that was just for my information, it sounded like, right?
Yes, just
All
to
right.
show compliance, Your Honor.
All right. So now down to the question of what to do about actual parent time. I am concerned that I don't have information today in large part because there hadn't been the ability of the guardian ad litem to have input. I think there would have been plenty of time for the guardian to at least to conduct initial investigation after their appearance had this happened. So I don't have that information, and it's I wish I did, but I think that I also don't think that I also find credible though that the missed parent time in part was due to an initial scheduling issue, and that since that's been resolved and schedules have been rearranged, that there's been more consistency with exercising the parent time. I'm going to, for today, expand for the weekends, just to have those weekends carry over through Monday morning and as opposed to Sunday evening. I'm not going. I've said from the beginning about taking baby steps. That on the one hand, on the other hand, I think that my concerns about whether or not the child would be subjected to some risk of harm would be abated by keeping the two parties together. I think that's happening. I still want to set it for another review. I'm not at a point yet where I want to say no further reviews, but for now I'll extend the weekend time. I'm also contemplating perhaps if there's no further issues. I think legitimate issues. I think a lot of what I've been received are complaints about the other party that don't necessarily go to parent time, but as to whether the parent time should be expanded, such as hiring private investigators. I just think that there's a lot going on here that's designed to inflame the passions of the finder of fact. But I'm not a jurist who hasn't been exposed to the court system in the past either, so I can filter some of that out. I mean, I really I hope that the parties can keep their pleadings relevant to the issues at hand. That's important moving forward. In some ways, I get a feeling like there's a desire to keep the drama going, that it keeps it in the news, that it keeps them relevant in the social media context. So I'm concerned about that too, and how they can have the effect that can have later on down the line with respect to the child who's probably still too young right now to have an understanding of the full picture of the dynamics between mother and father. I still want you to keep working on this case. So far, I think you heeded some of the advice that I provided for you, got into mediation. I really did truly appreciate you trying there. I want you to keep working at it. And another thing I want to say about this too is listen to your guardian ad litem. I've known Miss Satterley for a long, long time. I trust her. And that doesn't mean we all don't, that any of us get it right 100% of the time, but listen to what she has to say, please. And I think we'll have some better information when we come back. I'd like to have this actually be not that long out, closer to the last hearing was in the beginning of June. This is the beginning of July. So we went about 5 weeks out, right? The last time. I'd like to do that roughly the same. Come back maybe the first week of August, if I have an available slot in the afternoon. On what day? I can go 3 o'clock on August 3rd.
Your Honor, I'll be in a judicial settlement conference that afternoon.
How about the 5th?
I'm available then.
What time, Your Honor?
3 o'clock via WebEx, is that right? Okay,
I've
3
got
o'clock via WebEx.
I've got a 1:30 in person in Provo. Do you have perhaps a 3:30 or a 4 that might make it doable?
Try not to go that late. What about Thursday? August 10th at 2:30 we could do.
I can do that, Your Honor.
I'm available then, Your Honor.
And that works for us as well. And
Okay.
I do have a question once we have scheduling out of the way, Your Honor.
Okay, well, we'll reset it for a parent time review for August 10th at 2:30. By then, you should also have a ruling, hopefully, I don't know, maybe not. You don't even have a hearing date set yet with Judge Mao. So we still might not have a resolution on the motion to set aside the stipulation. Certainly if that's denied, then there may be big changes coming. All right.
And Your Honor, one observation, as we've tried to articulate and present in our filings, exchanges have been challenging here, and we'd like to simplify those as much as possible. And we think that a logical way to do that would be to transition the Thursday day visit to an overnight. That way there's a nice clean block instead of that back and forth.
I was thinking about that today. I'll be thinking about it at the next hearing. I mean, we're talking, what? 4, a little over 5 weeks out. I'm still thinking about that, expanding midweek visits to overnight. That's why I asked about whether she was exercising her midweeks.
Okay.
All
Understood.
right. Okay.
We'll prepare an order, Your Honor.
All right. Thank you, everybody.
Thank
Good
you.
luck. Keep working on it, please.
Okay.
Thank you,
Thanks,
Your
Your Honor.
Thank you.